Good afternoon, everyone. Am I audible?
Yes, yes, you're audible.
Thank you, sir.
रफी वो तिवारी है ना उनका जो जूनियर है। तनखा साहब का जूनियर तिवारी है, मिस्टर तिवारी। हाँ। हम्म। Sir, Mr. Vivek Tankha will just join, sir, within 2 minutes.
Right, we wait for him.
Yes. निकल करो जल्दी यार। हाँ जल्दी। हेलो। हम्म।
Yes, ma'am.
हार्ड कॉपी में देखा है? उसी में देख के तुम्हें मेल दिया है पर भी सबको एडिशन सक्सेसनल ये किया वो किया वो तो किया मैंने।
About to join. As it is written.
A very good afternoon, Tankha sir.
Good afternoon. Good afternoon. आप कैसी हैं?
How are you, sir? Thank you so much for joining. This is Dr. Rakhi Singh, Deputy Director. We have with us Lieutenant General V.K. Sharma. Over to you, Director, sir.
Sir, good afternoon, sir. I'm General Zinder. I'm the director of the Amity Law School.
Yes, of course, of course.
We welcome you, sir. We are so happy to have you with us.
Thank you, thank you.
And we are so excited to hear your wise comments about the three laws.
Thank you, thank you. Of course, it's a pleasure always been with amity, always.
And Lieutenant General V.K. Sharma, ABSM, he is the Pro-Chancellor, sir, of this university. And Professor Dr. M.P. Kaushik is the Pro-Vice Chancellor.
Lieutenant General Sharma Sahab is a famous personality.
Thank you so much, sir. And I extend a hearty welcome to you, sir.
Thank you, thank you.
So may we start, sir?
Sure.
Anchors, please.
When people learn tools of judgment and follow their hopes, the seeds of manipulation sown are demolished. We're extremely delighted by the gracious presence of Honorable Chief Guest, Mr. Vivek Tankha, Senior Advocate, Supreme
We have lost the connection.
Court Member of Parliament, Lieutenant Pro-Chancellor, Amit University, Madhya Pradesh, Officiating Vice Chancellor, Professor, Registrars, AUIT, Deans, Directors, all the HOIs, HODs, faculty members, along with the participants and the dearest audience. I, Trisha Bansal, and I, Ankita Tiwari, take this opportunity to welcome you all to the valedictory session of Virtual National Conference on Replacement of 3 Criminal Laws of the British Era by the Bharatiya Laws will lead to the decolonization and ushering reforms. In-depth analysis. We all are indeed elated and honored by your presence. We are delighted to unveil the souvenir, Ad Milora, which consists of various research papers, a book commemorating the national seminar conducted. Join us as we unveil this special publication celebrating the insights and discussions shared during the seminar.
Okay, we can skip the remaining papers and you can stop this sharing. Please proceed.
Keep your face always towards the sunshine and the shadows will fall behind you. Lieutenant General V.K. Sharma, Ati Vishish Seva Medal, retired Pro-Chancellor, Amity University, Madhya Pradesh, Gwalior, is an alumnus of erstwhile King George Shimla. He did B.Tech from College of Military Engineers, Pune, M.Tech degree from Pune University, and MMS from Osmania University, all in first class with honors. He joined the National Defense Academy and passed out as a permanent commissioned army officer from Indian Military
You
Academy.
can skip the introduction because most of the people know me already. So you can go to the next point.
A visionary divine pro-chancellor with a golden heart. I would like to request, sir, to kindly enlighten the audience with your valuable words of wisdom and concluding remarks. Please, sir.
Thank you. Mr. Vivek Krishna Tankha, the Honorable Member of Parliament, Rajya Sabha, also the Senior Advocate of the Supreme Court, former Additional Solicitor General of India, and former Advocate General of Madhya Pradesh. Sir, it's a great privilege that we have such an expert with us today, and I immensely thank you from the bottom of my heart for having spared your valuable time and come here to enlighten us with this subject, which is new, contemporary, and of interest to not only law students, but to all citizens of the country, because it will ultimately affect all of us from 1st of July 24 onwards. Over the last 2 days, we have been having deliberations over various papers which have been presented on issues, the repercussions, apprehensions about the new laws, how they are going to affect the society, how the changes are likely to be implemented, and how generally it is felt that the laws which have been now made are more stringent as compared to the laws of the British era, which were in vogue till now. Of course, some good changes have been done, but like, for example, the best thing is about the terrorism definition has been introduced, and a clause about terrorism has been introduced, which was not there earlier. Sedition mentioned under Article 124A IPC has been repealed from the criminal system of India, but another provision for offences that hurt the sovereignty and the integrity of the nation have been introduced. Mob lynching has been introduced in a much better manner, but in that again, it is felt that the aspect of religion which has been left may have implications in future. Also, the section 377 has been omitted from the Indian criminal system, which states punishment for homosexuality, but it has not been defined to the extent that even attempt for such a thing is there, it's a punishable offense or not. The minimum age of adolescent now been set from 7 to 18 years, and community service which has been introduced is a welcome step. I think every small offense does not require a punishment to be put in jail. Punishment like imprisonment for, I think, is too severe for very small offenses. And I think community service will meet the ends of justice for that. Also, certain other factors like timelines for verdict and charge sheet. Now, various timelines which have been introduced now under the new code provides a timeline of 30 to 45 days to pronounce the verdict after hearing the closure of the case. And in provisions of CRPC, no such timeline was enunciated. It was vaguely provided that verdict to be declared either immediately or at some subsequent time. Now, at least a timeline has been set. Another important development is that the charge sheet shall have to be filed within 180 days, and the magistrate will have to take cognizance of it within 14 days. Even I feel this 180 days is quite a time. That means 6 months of time to file a charge sheet, which we feel that it is too long, and probably that should have been reduced. And the police has been mandated to register an FIR within 3 days if it finds merits after a proper investigation, and if it finds that there is a prima facie case. The provision of zero FIR is an important welcome step, and the victim can go to any police station and lodge a zero FIR, and it will have to be compulsorily transferred to the concerned police station within 24 hours. Otherwise, that was a big problem, that the persons had to go to a police station which is under the jurisdiction of where the crime was committed, so which itself was not a correct thing to do. Another thing which has been introduced is like more discrete laws for enforcement officers like police, directorate of prosecution, etc. The new criminal code has criticized to a good measure the providing police law enforcement officers with greater discretion. For instance, the officer not below the rank of superintendent of police shall decide whether the accused to be tried under UAPA or BNS. This has propensity to increase misuse. Also, the police has been given powers to keep accused in police custody beyond the initial 15 days of arrest. So there are many such provisions which are debatable, and only time will tell how effective these are. But in my views, while the laws exist in India, and they existed and they will continue to exist, what is more important is the implementation of these laws. And beyond that, what is more important even that is that the populace, the people must understand that unless they become law-abiding citizens, India cannot gain Viksit Bharat status. Viksit Bharat status of a developed country can only be gained if our citizens are aware that they need to obey the law, and the laws are meant to be obeyed, and they themselves take pride being a law-abiding citizen. That is what is required, and that can best be achieved through education, not only at college, university level, but also educating the masses, which is the job of the graduates and postgraduate students who are now studying law. It is our duty to ensure that the knowledge about these legal issues reaches the ground level, and we ensure by taking off people who are not abiding law and telling them that this is something that wrong you are doing. If somebody is, for example, throwing the garbage on the roadside, how many of us would dare to go and point him out and tell him, please don't do this. This is not done. You are making the city unclean. People will just look other side and go away. This is what is happening. And some cases of hit and run, all those things which are happening on the roads, we know that the punishment has been made now more stringent, how the drivers were against that, but then ultimately the things have to take place the way it is. So I will leave it here, and we would like to hear more from the expert who is there with us. And I'm thankful to all the organizers for this seminar which has taken place over the last 2 days, and excellent thoughts that we have heard from various speakers and papers that we have received, which we shall now be publishing, which are in a compendium. So thank you very much for the patient hearing, and Jai Hind.
Thank you, sir. Now I request Professor Dr. Rakhi Singh Chauhan, Deputy Director of Amity Law School, Amity University, Madhya Pradesh, Gwalior, to kindly present report with regards to the session which were conducted over the event. Please, ma'am.
Thank you so much, Ms. Krisha. Am I audible?
Yes.
Yes, ma'am, you're audible.
Honorable dignitaries, Amity Law School has organized a virtual national conference on this very vibrant topic, replacement of the 3 criminal laws of British era by Bharatiya laws. And this will lead to decolonization and ushering reforms and in-depth analysis. And it was organized in these 2 days, 21st and 22nd of March, 2024. We have 8 related sub-themes of this conference on this topic itself. 100 participants registered to attend this conference, and 51 research papers were received for paper presentation. We had inaugural session yesterday, that is on 21st of March, where Professor Dr. Nishtha Jaswal was the chief guest and keynote speaker. Dr. Nishtha Jaswal is at present, recently she has joined as Vice Chancellor, Dr. Bhimrao Ambedkar Law University, Jaipur, and she is former Vice Chancellor of Himachal Pradesh National Law University. In this conference, for the paper presentation, we had 5 parallel technical sessions, which was organized for these 51 participants. And this was brutally judged by the resource person of these technical sessions. That was Dr. Ankit Awasthi, Assistant Professor of Law, Senior Scale at Hidayatullah National Law University, Ms. Sangeeta Pachauri, Advocate at Madhya Pradesh High Court, Gwalior, Ms. Neha Tomar, Judicial Magistrate, Madhya Pradesh, Dr. P.C. Mishra, Associate Professor, Sri Ram Swarup Memorial University, Lucknow, Dr. Afkar Ahmed, Associate Professor, G.D. Goyanka University, Dr. Kanchal Gupta, Associate Professor, UPES University, Dehradun, Dr. Tawheed, Assistant Professor, UPES University, Dehradun, Dr. Sadanand A. Karhale, Assistant Professor, ICFA University, Hyderabad, Dr. Shilpa Rao Rastogi, HOD, Vivekanand Global University, Jaipur, and Dr. Gurmanpreet, Associate Professor, Rajiv Gandhi National Law University, Patiala. In this conference today morning, we had a good panel discussion which took over on 22nd of March 2024. The panelists were comprised of Dr. Ritu Gupta, Professor, National Law University, Delhi, Dr. Preeti Jain, Professor, Kurukshetra University, Mr. R.H.A. Sikandar, Advocate on Record, Supreme Court of India, Dr. Ruchi Sapahia, Associate Professor, Himachal Pradesh National Law University, and Mr. Chaitanya Singh, Advocate, Supreme Court of India, New Delhi. And of course, to motivate the research paper presenters, we have the award in this conference in the following sequence. The best paper presenter, he or she will be awarded with a cash prize of rupees 3,000 and the certificate. The second best presenter, rupees 2,000 and a certificate, and best research paper, rupees 2,000 and a certificate. To motivate the paper presenters, because we understand that required a good skill and hard work, we have consolation prizes for each technical sessions. For outstanding research papers, Amity Law School is going to publish the papers in conference book with ISBN number. The unveiling of conference seminar is already done in this valedictory session. And here we are in this valedictory session where we have Mr. Vivek Tankha, Senior Advocate and Member of Parliament, as chief guest in the valedictory session. So not taking more of your time, over to anchors again. Thank you so much.
Thank you, ma'am. Honor is not a matter of any man's calling merely, but rather of his own actions in it. Shri Vivek Tankha is a distinguished senior advocate at the Supreme Court, known for his unwavering commitment to service above self. Throughout his career, he has maintained a balance between representing top corporate houses like Reliance, Tata, Birla, and Adani, and providing pro bono legal aid to the poor and needy. His professional journey includes serving as Additional Solicitor General of India, where he represented the interests of the Union of India and various state governments in high-profile cases. He has also appeared before constitutional benches of the Supreme Court and represented the Government of India in international arbitrations. During his tenure as Advocate General for the state of Madhya Pradesh, Shri Vivek Tankha played a pivotal role in key legal reforms and initiatives. He advised on the decentralization of powers through the Panchayati Raj Act, reorganization and restructuring of Madhya Pradesh Power Board, and represented the state in various courts regarding the Bhopal gas tragedy. Shri Tankha's contribution extends beyond his legal career. He is also a member of Parliament Rajya Sabha and has been actively involved in social and humanitarian activities. He has led relief efforts during natural disaster, established schools for specially abled children, and organized health missions benefiting thousands in tribal areas. During the COVID-19 pandemic, Sri Tankha launched a web portal and helpline to assist the migrant workers, students, and others stranded across the country, helping thousands to return to their homes. His efforts have been instrumental in providing relief to those affected by the pandemic. Internationally recognized for his work, Shri Vivek Tankha has received the International Global Quest Award at the Rotary International Convention in Barcelona, Spain in 2002. His dedication to legal excellence and humanitarian causes makes him a true leader in both professional and social spheres. Now, it is this belief in the need for the empathy that provides me the cue to humbly invite Sir to please enlighten us with his words of wisdom. Please, Sir.
Thank you so much for this lovely introduction. I'm delighted to be addressing the Amity University Law Faculty. And so delightful to see people like General Sharma, a legend in his own rights. Major General Rajendra Kumar ji, who was also a Judge Advocate General. Dr. Bedi, Ms. Chauhan, and Student Coordinator Aditi, and so many distinguished faculty members present here, and I'm sure so many young participants who are presenting papers or doing research or just participating in this seminar. You've chosen a very current issue. This current issue stems out of the last parliament session where these three bills were introduced. But unfortunately, because of our democratic polity of systems and huge disagreements between political parties, as an opposition, we could not participate in the discussion for passing these bills, which is my bail. In fact, Dr. Abhishek Singhvi and myself would have been the two lead speakers in the debate, and we would have loved to contribute in the lawmaking of this particular three laws, because we knew it needs a lot of changes, a lot of amendments which were necessary, and that's what Parliament is meant for. But lawyers may want Parliament, but politicians sometimes are happy without Parliament. There's a difference between a lawyer politician and a normal politician. But let me tell you that I'm highly impressed with the new technology which has stepped into our courts and our universities. Before 2019, before COVID set in, it was unthinkable for me that I could address Supreme Court and High Court sitting in this office like I'm talking to you. It was unthinkable. Today, I'm able to argue cases sitting in my office, whether in Supreme Court or different high courts, or I'm addressing conferences like the present one. It's a great march of technology. And technology is always something which brings changes. We are all looking for compact hours of study with no wastage of time. And today we are coming to that stage where even courts someday will have to ration time for lawyers when they want to argue these cases. America, they ration. You can't argue more than half an hour or 40 minutes. There's a ration. You have to give your written submissions. Before I step into the three laws, let me tell you that for me, these three laws were, as they existed from Lord Macaulay's times, were like the Magna Carta of criminal jurisprudence. Sometimes I actually wonder that Lord Macaulay, with his precise definition of various criminal acts in the IPC, must have been a genius to create a law which lasts more than 100 years. And with there were amendments, of course, but very few amendments. But nobody could actually challenge or amend the basic flow of the theme that he brought into the criminal jurisprudence. The way he bifurcated the criminal jurisprudence into different offenses. And for years and years and years, that became the byword. One of the things which I wanted to tell the parliament was, by bringing 3 new acts and not amending the old act, we'll have to realign ourselves to the new sections. It's a huge task. Putting it in a very lighter way, 420, 420 is well known in all parlances, common parlance, that it's cheating. Now today, if a policeman has to book somebody for cheating, he'll have to search for which section. 302 हर आदमी के जबान में था. It used to be 302 means murder. Now that has changed into another section. So there has been a complete realignment of sections, which will take some time to settle down. Whenever you bring new laws, they take time. CRPC, which first came into existence first time in 1882, then was amended in 1898, and finally replaced by an act of 1973, brought in new sections. But for years in litigation, we used to find old sections and new sections being compared. There were overlapping interpretations. There were new interpretations also. So bringing in new laws also means a lot of legal confusion for some time at least, and which in this case I think will stretch for many years, because definitions have also been changed. I'm happy to tell you that I'm also one of those who's a votary of change. I have nothing against change, because as mankind progresses, you think of new developments. Of course, changes do come. But my first feeling is always you should only change a thing if it's necessary. If you are comfortable with the existing setup and you can do with amendments, maybe that's an easier way out. But then it's always the prerogative of the ruling government to whether to bring in new law or to come forward only with amendments. So they came forward with new laws, which will get operationalized from 1st of July. Now, looking at those new laws, let me tell you, I saw so many of them, as General Sharma rightly said. Now, when you see CRPC, it's a good thing that they are putting a timeline to closure of investigation. It's a good thing, because you can't have investigations going on for 2 years and 3 years or 10 years, which happens today in many cases. So you have to bring it to an end. That's a good thing. They've extended the time for charge sheet from 90 days to 180 days. FIRs, they say, should be maximum 3 days. Supreme Court, in its judgment, had said it should be immediately if it's a cognizable offense. But then sometimes they need to have a look at it, because a lot of times fictitious and false complaints are made. So some amount of screening and pruning needs to be done at the level of police. So maybe 3 days is the maximum, but wherever there's a cognizable offense on the face of the record, they'll do it immediately. Long custodial interrogation has never been appreciated in a civilized world. If you look at the success of a police force is not by beating up the man in custody and taking confession or information out of him. It is by scientific investigation, by good investigation, that you come out with good evidence and book a man. If you go abroad, custodial interrogation is not a key to any investigation. Not so much as it is in India. India, it looks as if we rely completely on custodial interrogation. We try to get the story out of the man by beating him black and blue, and then try to match it with the evidence which the police then later collects. World over, it's the other way around. You collect evidence first and then speak to that man, putting across to him what has been collected by the police, and he is confronted with it. So I feel sometimes that our jurisprudence has been not the most civilized jurisprudence at times. Bail was always a rule in most civilized countries, unless it's a heinous offense, unless it's act of terrorism, unless it's a case of dacoity or rape or abduction, which is a threat to the society or its existence. But in normal circumstances, bail is always the rule, and that is why Supreme Court in its judgment in Amresh Kumar said that up to 7 years, you should not arrest a man. They told the police, send them a 41-day notice, call him for your investigation. And the right thing is not to first catch him, put him in behind bars, then find out whether he done that crime or not done that crime. So this approach which we have had of investigation, I find it not the best. And that is why Supreme Court in that famous judgment of the old DGP, I think, Prakash Singh, they gave various orders and said it is time right for India to have a separate investigation police force and a separate law and order police force. The same inspector who investigates your murder case also goes to receive a minister at the railway station, also is on law and order duty, also would be summoned to a college if there is a halla gulla in a disturbance in a public place. So you can't have investigators doing both things together. So there is a crime need, and very important, as Supreme Court has said, and which has not happened. First of all, to have a specialized force for investigation of crime and a separate force for law and order, and don't mix up the two. Which is in Madhya Pradesh, we still have the same old system. In many states, it's the old system, but gradually now specialized investigating agencies are being set up, though those are only for a limited purpose, like there's a state EOW, CBI does specialized investigation, NIA does specialized investigation. But as a rule, in general cases, you would find the same police officer doing both the duties. And we have seen how some of the cases get spoiled in the process, because halfway down the investigation, the man is called away for law and order issues. Then he comes back after 1 day, 2 days, 3 days, and then restarts the investigation. And when you put these things in cross-examination, that why did you take 3 days after the first step, he would not have an answer, and there would be an adverse inference against what he has stated in court. So CRPC, yes, there are changes that have been made, but those changes are something which we are all not very happy with, because if you are a human right activist, you don't like long custodial interrogations or custodial arrests. You don't like FIRs being prolonged in a police station, and you also don't like that investigations should be haphazard. So we need specialized agencies, specialized way of thinking, and specialized way of taking our criminal jurisprudence and criminal administration of justice forward. But coming to the changes in the new Bharatiya Nyaya Sanhita, I mean, commonly the word I use is Indian Penal Code. We'll have to get used to these words because they are not part of our legal dictionary or parlance so far, but we'll get used to them. It's a matter of time. But sometimes I feel that there are some good parts, and they're not ambiguous parts also. But the good part is that, as the General Sahab also mentioned, is community service. You know, for every small crime, or for every crime, unless it's a major crime, why do you want to crowd your jails? I have been, as a parliamentarian, going to these jails, visiting jails. I have been to Bombay jail, Otter jail. I have been to Chennai jail, Bangalore jail, Hyderabad jail, Delhi Tihar jail. We have met inmates, we've spoken to people. Jails are overflowing with under trial prisoners, even pending cases. Why do you want to keep people there? Unless they are people with heinous records, or sadistic people, or bad people, who was unsafe for the society. Why not make them work? Why not ask them to do community work? Why not make them work in the field of the farmer who they have killed? Let the man who has killed the bread earner farmer, let him go and work in the field and report to the judge or the probationary officer under his supervision and monitoring, and give real help to the victims. Problem is the victim doesn't get assisted by your criminal justice system. That is why this community service is a step forward. But it is still a far way off. It only is for some sections, very few sections. It doesn't allow community service in a large number of sections, offenses. So community service has to be on a larger trajectory. If you go to US, jail is not the rule. It gets converted into community service very often. I remember in one case, that BMW accident case, hit and run case, which the accident happened sometime in the 90s. Then after a trial, the accused are acquitted, convicted, but convicted for 1 year or 2 years or whatever. State files an appeal that no, this is not just a hit and run case. It's not just rash and negligent driving. It's culpable homicide not amounting to murder. And that is argued in Supreme Court after 25 years, 20 years or something. By this time, this gentleman who served 2 years in jail, he's come out, he's got married, he's got children, he's got into a big business. And suddenly one day there's a Supreme Court order that your jail sentence is going to be enhanced by another 3 years. But Supreme Court then thought it's unfair to just send a man again after 20 years back to jail. He has progressed so much in life. He only, today not only he, but the family also suffers. The children also suffer. So they actually, without a law, brought in community service as a punishment model. And in that case, that gentleman was given, I think, 2 years community service work under the supervision of Government of India to be done in some village of Himachal Pradesh. So what I'm trying to say, community service is a very powerful weapon of penology. It should be used far more in India. Now, another thing which we don't use in India is plea bargaining. Plea bargaining is very common in US. Why should every case, in India you have lakhs of cases, small and big. Why should they all go to trial? Why can't they finish at the first stage or second stage? Why can't we lawyers be also more responsible? First of all, in America, I think the office of a lawyer has a lot of duties attached to it. As a law officer, you have you are duty bound to the court also. And that is why in a lot of plea bargaining cases, the lawyers advise their clients, hey, you've done wrong. You have to accept your crime. But if you accept your crime, instead of sentence, you will be given fine, or you will be sent for community service, or it's a case of reduced fine or a reduced sentence, depending on what is the offense. Now, why isn't all that happening? Plea bargaining has come into CRPC. But the other day, it was being mentioned in Supreme Court. It's a section which is hardly used. As I said, we also need to change our mindset. The ethos of practice of law also needs to change. And I think, Jalal Saab, it's the young children who are going to get into these, when they come into these, the system of law. It's these children who are going to be, these students who are going to change the law more than us. Because they are more open to these suggestions. They are more open to these ideas. They are living and breathing with these ideas. So I'm happy that institutions like Amity are engaging in such fruitful discussions, so that the students of tomorrow will be today will be the icons of tomorrow, are engaging themselves in such good debates. Another, I mean, I could talk of so many sections about this this IPC, new IPC. You know, like for instance, organized crime. Now, organized crime is not defined. So we don't know what it will stretch. Today they say that cheating, even if you sell a picture ticket in an organized way every day, it's an organized crime. Bootlegging, betting, gambling, all other and similar acts. So today, organized crime ambit has been increased to such an extent that we don't even know where it ends. So I don't know whether it is susceptible to be misused at some point of time, and then it's going to be overlapping with other laws also. Then petty organized crimes. Then frankly speaking, there's no definition of petty organized crimes. Again, it's the same. Then even now terrorist act. Now terrorist act has become again a very wide definition. Contract killing, mass killing, fraud, cyber fraud. I mean, land grabbing. They brought in so many facets of these of today's day-to-day life. Maybe our lives have become more complicated. Maybe they're correct that they envisage all these aspects of our lives, which will turn the society into some sort of a violent society, ultimately where people will have to be punished. So as I said, maybe we are wrong. We are at a cusp of time where we are not able to see these things so much, because as we grew up, we were more accustomed to the traditional crimes. Who was a traditional criminal lawyer? Who used to do murder trials? Who used to handle rape trials? Who used to handle dacoity or the theft trials? But today again, these are outdated lawyers who do these things. The new lawyers, the new generation lawyers are not interested in these trials. They're interested in white collar trials. It's the corporate trials. It's the cyber crime. It's crime arising out of new generation laws. So as I said, the world of law is also changing. So if a new law has been brought, it's fine. But I don't know. You may have to change this law after 20 years also, because the world is changing. Your thought processes are changing. What is a crime today may not be a crime tomorrow, and what was a crime yesterday may not be a crime today. So all this also keeps changing. So what I'm trying to say is that sedition, now everybody thought sedition is a bad law. It was brought by the Britishers to subjugate the people of India. This is the pre-independence era. And Supreme Court was criticizing it, public was criticizing it, everybody was criticizing it. But the new definition of sedition is more expansive than the old definition if you look at it closely. So what have we changed? We criticized that sedition is a bad law and brought in sedition through another name which is wider than what was envisaged later. Again, I'm very careful. I'm again cautioning. My problem is, as a lawyer who has spent 40 years in the practice of law, don't make this a police state. The more and more we get into these acts, the more and more we empower the police, which may be a compulsion of times, though I can't deny that also. The more you become a police state, the more and more people are going to be subjected to all kinds of repressions. So I firmly believe crime is fine, and crime has to be handled well also, professionally also. But yet at the same time, crime needs to be handled in different different ways also. For everything, you don't start bludgeoning people. For everything, you don't start putting them behind bars. Maybe more reformatory methodologies will have to be evolved in the times ahead, so that we come out with a penology which is in tune with the times. As I said, homosexuality was a very bad word and a very bad offense. Supreme Court struck it down, said no, 377 is not an offense. So all I'm trying to say is that we have new laws. From 1st July, we will enter into these new laws. And these new laws have brought in so many new facets of definitions, whether it be of cruelty, whether abetment outside India for offences in India, hiring and employing of engaging or children to commit offence. I mean, I could keep reading. Every section may have some new facet or the other. But all this is a newness which has come out of new thinking. This new thinking will have to be tested in courts. We'll have to again see how this new thinking helps to curb crime, or maybe it is in excess of what we think is required in law. But all this is now open. It's only after 1st July, when the new laws step in that and get tested in courts of law, that we'll see that whether how much of it can be sustained and how much of it cannot be sustained. In any case, no law can be perfect. Whenever anybody has indulged in lawmaking, you can't make a law for all times to come. The laws have to have their own lifelines. So maybe our IPC and our CRPC and Evidence Act had their own lifelines. India has changed. India is now India is heading towards a new generation of industrialization, a new generation of progress. Indians are doing so well world over. I can see Indian doctors, even Indian lawyers today are sought after all over the world. In a situation like this, when I see Amity and other institutions doing such good work, I can only say congratulations to the people who are organizing all this. Please carry on with this good work that you're doing. You're doing yeoman service for the country, Dr. General Sharma and General Rajendra Kumar. I know Dr. Ashok Chauhan very well for a very long time. We have been friends from, I think, 20 years or 25 or 30 years. When he had just started Amity in 2005, that's the time we started knowing each other. I used to go and speak in your main campus also in those early days. Now, of course, it's so much happening in my own career and life. It's difficult to find time. But yes, let me tell you, I enjoy sharing my moments with young students, because it is these students who are the future of India. It's these students who will help preserve the democratic fabric of India. And it's these students who will make our administration of justice and the legal system good and robust. Thank you, Jai.
Thank you, sir.
Just
I
one
request
minute,
Dr. Sanjay.
just 1 minute, hold on. Mr. Vivek Tanka, sir, thank you so much for your kind words and sparing so much of valuable time. And we are really, students would be very happy. They have learned so much from you. Kindly permit me to leave this conference, sir. I have got another engagement. So I hope you won't mind doing that, sir. Thank you so much, sir, and thanks a ton. Yeah, please carry on.
Thank you, sir. I request Dr. Sanjum Bedi, Associate Professor and Coordinator, to kindly announce the results. Please, ma'am.
Thank you, Prisha, for giving me this opportunity. Karmanya Vadikarastu Ma Phileshu Kadachan. This shloka emphasizes the importance of focusing on one's duties and not worrying about the results. Good afternoon, respect-worthy dignitaries, honorable chief guest, and dear participants and the audience. Today, the time has come to reveal the winners. Undoubtedly, winning gives a sense of happiness along with a sense of responsibility, fulfilling new commitments and dedication. I take pride in sharing the names of the winners. My heartiest congratulations for the Consolation Award for the participants of each technical session. Technical session 1, the consolation prize goes to Yashika Manchanda and Khushi Datwani. Congratulations. For technical session 2, the consolation award goes to Dharmendra Yadav and Devrat Anand. For technical session 3, it goes to Vinny Saxena. For the technical session 4, it goes to Mukta Garg. And for the technical session 5, The consolation award goes to Dr. Niti Pandey. Coming on to the second best presenter, we have this award being awarded to Luksha and Sadhana Sai. The best presenter goes to Devrat Anand and Dharmendra Yadav. The time is to announce for the best paper award. This goes to Ankita Singh. The paper was read as it titled as an analysis of the strict approach against hit and run cases in the Bharatiya Nyaya Sanhita 2023. Congratulations to the winners. Thank you very much.
Thank you, ma'am. Congratulations to all the winners. Vision pulls you when you are greatly determined to work forth. Major General Rajinder Kumar, Adi Vishishta Seva Medal, Sena Medal, Vishishta Seva Medal is an alumni of Indian Law Society's College Pune and did masters from Pune University. He got enrolled.
Jen Saab, can I leave with your permission? I have people waiting for me. Jen Saab, can I leave with your permission? There are people waiting for me.
Thanks, sir.
Thank you.
He got enrolled as a Judge Advocate General with Bar Council of Maharashtra and Goa in 1981. Instead of pursuing his career as an advocate and a law teacher, he joined Judge Advocate General's Department of Regular Army and superannuated in the rank of Major General as Judge Advocate General. After superannuating from Army, he took over as Director of Amity Law School, AUMP, in September 2017, which is progressing by leaps and bounds. Now, I request our respected Director, sir, to kindly deliver the vote of thanks. Please, sir.
Thank you very much. Am I audible?
Yes, sir.
First of all, let me thank Mr. Vivek Krishna Tankhaji, Senior Advocate Member of Parliament, for having spared his valuable time to be here with us to deliver a talk on such important issues. I had known Vivek Krishna Tankhaji since 2008, when he was Additional Solicitor General of India, and I was posted in Army headquarters dealing with court cases of Army in 2007 and from 2007 to 9. That time I interacted with him. So we all thank him very much for sparing his valuable time to attend this conference and share his valuable thoughts about these laws. I also thank our revered Pro-Chancellor, sir, for having allowed us to organize such an important national workshop for the benefit of our students. We also thank Dr. MP Kaushik, sir, for the Pro-Vice Chancellor, for sparing his time and guiding us to organize this seminar. We also thank Dr. Jaswal, who was the chief guest at the inauguration ceremony of this workshop, for sparing her valuable time and addressing us all. And the panel member, Dr. Ritu Gupta, Dr. Priti Jain, Dr. Rachi, Dr. Ruchi Spaya, Mr. Charinde Singh, Advocate, and Mr. R.H.A. Skandar, Advocate to the Supreme Court, who very kindly spared the time to be the panel members and addressing the conference. Thank you very much. Of course, they are not here, but I thank them all. We also thank the organizing committee of this conference, who spared so much time to organize this conference in such a meticulous manner. Thank you all the committee members and of course the organizing committee.
Sir, may I beg your pardon. There was a
technical error due to which this glitch happened. So the best presenter award that goes to Sarvesh Soni and Bhartendu Chaudhary. So let me please clarify that. And yes, and for the technical session 2, the consolation award goes to Dharmendra Yadav and Devrat Anand. Thank you very much.
We also congratulate all the winners of these awards who I've gone through all these papers. They've written very, very good papers, giving their thoughts about these new criminal laws, which will come into effect from 1st July 2024. In fact, we selected this topic because these laws will come into effect from 1st July 2024, and IPC evidence and criminal procedure code will not be invoked. The more the reason that our students and all the faculty members should be aware about these laws. There is a certain shift from the traditional criminal laws to the new Bharatiya laws. So they need to be aware about all these things. I don't want to take more time. I thank all of you for helping us to organize this mega event. Thank you very much.
Thank you so much, sir. With this, we mark the end of this valedictory session. I thank all of you and have a blissful evening ahead. Thank you.